Hello and welcome to our media outreach platform. I'm Advocate Gaurav Gautam, and in this video, I'll be discussing with you law relating to FIR, how to get your FIR registered, what are the statutory provisions dealing with the registration of FIR, what is the detailed procedure, and what if a police officer denies registration of FIR, where can you go, what can you do, what remedy lies in court of law, and various Supreme Court and High Court judgments on the issue. So, before I begin, I would say that registration of FIR for many of us and for most of us, it's our first face-to-face interaction with a police officer, and I would say if you're not well informed, it's a pretty daunting experience, and it seems like you are at the mercy of police officer, even though this is not the case. So because lack of information makes you feel like more miserable because you don't know. It seems like you are at the mercy of police officer, and he seems like in a position of absolute power, which is absolutely not the case once you know the law. Before I begin, I just wanted to share my experience with police when I was in college. I was 17, maybe 17, around 18. I was first year in college and I lost my cell phone, and I went in for registration of FIR in a police station, and the police officer said to me, "Oh, where is your affidavit? You need affidavit for registration of FIR." And I was not thorough with the procedure. I never in my life had registered an FIR before. So he asked me money. He said, "You need to pay 100 rupees for affidavit." And I was taken aback by what he said, and without thinking I gave him the money. The reason why I did that, because I wasn't aware. I thought this is the procedure. Only later I came to know that there is no fees for registration of FIR, no affidavit is needed, no stamp is needed, no e-challan or anything such thing is needed. So manipulation happens when you have no information. So the beginning point for any manipulation or any mishandling to take place is you being not well aware of the law of the land. So this is my intention. This is the intention of Mr. Ajit Singh, whose initial idea it is to make video informing the citizens about the law, that you are in a better position to you exploit the laws that are made for your benefit. So first question first. Legally speaking, what is FIR? Which document exactly constitutes FIR? So in terms of definition as provided under section 154 Crpc, legally speaking, FIR is a written document prepared by police officer when they receive information about commission of a cognizable offence. So what is important here is two things. First, for example, you give a written letter to police officer. That is not FIR unless he records it. So the FIR is a document which police officer prepares, which is the first ingredient. And second, it is the information about commission of cognizable offence. So what is cognizable offence? Not all crimes are categorized as same in CRPC, which is the procedure law for investigation and court procedures. It has made distinction in the crime. For example, more heinous crime in which police have power to arrest the accused person, anybody accused of the crime without arrest warrant from magistrate. So those categories of heinous crime like murder and rape and robbery, like that, such offences are cognizable offence. So FIR is under section 154 is information that is recorded by police officer, and that information should disclose commission of cognizable offence. Now, if you need a complete list of what offence are cognizable and what are not cognizable, you can find that list in first schedule, which is given at the end of CRPC Bear Act. So back to the issue of nature of FIR. So I would say, in practical terms, once you see a crime, once you are a victim of a crime or you witness a crime being committed and with family members, or you are a citizen and you see a cognizable offence being committed, so the very, very first step that you have to take is to get an FIR registered. So And often I have seen that there is a lot of confusion in the minds of ordinary people, especially in the cases of bribery and corruption and criminal misappropriation, like that. So they start making representation to CM's office, Prime Minister's office, and Vigilance Department, Departmental Grievances Redressal Forum, like that. These steps are important, but none of these institutions are under legal obligation to conduct any investigation whatsoever. So you may see any action, any follow through, or you may not see any follow through for years to come. But real first step that is needed in such case is to file an FIR in a police station, so that uh, the investigative machinery that is established by law in India can be put to use to investigate the commission of that offense. So back to section 154. So far we have seen what constitutes an FIR. So apart from that, section 154 provides a specific direction as to how a statement is to be recorded in case of gender sensitive offenses, like where a woman's modesty is outraged, or in case of rape. And in such offences, the statement is to be recorded by a woman police officer. It further goes on to say where the victim is, temporarily or permanently, mentally or physically disabled. So in such cases where there is element of disability, the victim will have the right to choose place of her convenience, and the police officer concerned will go to that place and record the statement, and such process will be videographed for records. It further provides that the magistrate concerned in the case shall record the statement of victim under section 164 as soon as possible. Now in clause 2, a clear direction has been given to the police officer concerned that a free copy is to be provided to the informant. So it is your statutory right emerging from section 154 subclause 2 that you are entitled to get a free copy of FIR. It's a statutory right, so nobody can deny it. So there is no price tag on getting a copy of FIR. So in clause 3, a check and balance measure, or you can say a redressal mechanism, has been provided in case where police officer concerned refuses to record your information as an FIR. What to do then? So clause 3 section 154 says that in that case you can write a postal letter addressed to superintendent of police. In that letter you have to provide all the substance of all the information that discloses commission of cognizable offense, and if the superintendent of police is satisfied that yes, this information so provided has revealed commission of cognizable offense, he can either investigate himself or he can direct any subordinate officer to investigate the offense. The next section relates to commission of non-cognizable offenses, section 155. It simply states that every time you give information to police officer regarding commission of non-cognizable offenses, which means, as I've said earlier, these are the cases of non-heinous categories. For example, public nuisance, causing provocation for breach of peace, or cheating or forgery, like that. Such offences are not so heinous so as to be investigated by police officer on their own. For such cases, if you give information, police would record it in its police diary or other records to be kept as per state government's direction, and police will not automatically start investigation unless there is a direction from magistrate. And when such investigation happens, police cannot arrest while investigating. So there is a difference in cognizable and non-cognizable investigation. In cognizable cases, police can arrest suspected person or accused person without any warrant, but in case of non-cognizable, such arresting power is not available with the police. So, and last bit, it's very important, in section 155 it provides explanation for cases where the narration of facts disclose commission of two nature of offences, one being cognizable offence, one being non-cognizable offence. In such cases, the offences will be treated as cognizable ones. So it will be a cognizable case, and section 154 will apply, and the police will register an FIR. Even even the information, bits of the information reveal non-cognizable offense as well. So in that case where some part reveals cognizable offense, some part reveals non-cognizable offense, the procedure to be followed by the police will be for cognizable offenses only. Section 156 is very important, which is the next section, and this is where under this section we have power to approach court in clause 3. So I will briefly tell you what section 156 says. 156 states as follows. It's about police officer to investigate cognizable offenses. In clause 1 it simply says that for officer in charge of police station where he has information about commission of cognizable offense, he don't need any magistrate's order to start investigation. He can do so. In clause 2 a protection has been provided to police officers that if he so investigates, his investigation shall not be called in question on the ground that he that such officer was not empowered to investigate. And in clause 3, which is very important, where our remedy further is provided, the text simply says that any magistrate empowered under section 190 may order such an investigation as mentioned above. So what simply the text, it does not clarify, but what it implies and what happens in as a matter of practice is that if in case superintendent of police, you wrote letter to him and he does not respond, or there's no action, there's no follow-up, or even if you have filed an FIR but that no action has been taken, so in that case you have power to approach magistrate's court, and magistrate court can order registration of FIR under section 156(3). So I'll go into more detail into section 156 subclause 3 application, where you can approach magistrate courts for getting your FIR registered or for monitoring of investigation. But before that, it's very important that I inform you about very important, crucial Supreme Court judgment in which the duties and responsibilities of police officers were clearly laid out, and a big loophole exploited by police officer was closed down. What happened, this is obviously Lalita Kumari judgment. I'll go in great details, I'll give you the citation and everything. But before I go into this directions issued in this judgment, I want to tell you used to avoid registration of FIR. So what they used to do is, once you inform that such and such offense has been committed, so they used to say that, oh, all right, I will not register FIR unless our preliminary inquiry is complete. So they used to say, first I will conduct my preliminary inquiry, and if I find that cognizable offense has been committed, as you are saying, then only I will register an FIR. But what Lalita Kumari judgment clearly directed police officers, that you have no liberty, that in case the facts as are communicated to police officer factually disclose as per the information given, that yes, our cognizable offense is made out, you have to register it. There is no escaping on the excuse of holding preliminary investigation. So it's very important. The whole citation is on your screen as well. I'll read it for you, the directions that were issued in this judgment. So there are altogether 8 specific guidelines issued in this Supreme Court judgment. The first one, I will read all of them and I'll explain you each and every one of them. So the first guideline says that registration of FIR is mandatory under section 154 of the code if the information discloses commission of cognizable offense and no preliminary inquiry is permissible in such a case. This is as simple as I was saying earlier, that yes, the facts disclose cognizable offense. Now, the moment it reveals cognizable offense, the facts constitute cognizable offense, that the moment it happens, there is no scope left for holding any nature of preliminary inquiry, and no preliminary inquiry is permitted. This is the first guideline. Now the second guideline says that if the information received does not disclose a cognizable offense but indicates necessity for inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not. So what it does is it narrows down the scope of preliminary inquiry to the specific question that whether the information so provided reveals cognizable offence or not. So beyond that, there is no liberty provided for conducting any preliminary inquiry. Now, the next guideline is in the continuation of this guideline only. It goes on to explain that yes, where preliminary inquiry is is initiated to ascertain whether the facts as disclosed reveal commission of cognizable offence or not, what to do then. So the third guideline says as follows: if the inquiry discloses commission of cognizable offence, the FIR must be registered. There is no escaping from registration. And it goes on to say further, if in case where preliminary inquiry ends in closing the complaint, a copy of entry of such closure must be supplied to the first informant forthwith and not later than 1 week. It must disclose the reason in brief for closing the complaint and not proceeding further. So what it does is it says that, for instance, in case where preliminary inquiry was conducted and it is found that no cognizable case is made out, so police officer cannot orally escape his responsibility and say, oh, no offense is made out, what can I do? He has to give in writing his closure report, and such report is to be provided within 7 days. So what this guideline specifically does is that it creates another set of rights, though not mentioned in the CRPC provisions. It creates another right. It provides another safeguard for the informant, that even if his report is not registered on the ground that the information so provided does not reveal commission of cognizable case, but in that case also he will get a closure report with detailed reason. There cannot be any oral denial by the police officer concerned. So what it does, it pins down accountability on the officer concerned. There cannot be any oral denial as was happening previously. So the next guideline provides that the police officer cannot avoid his duty of registering offence if cognizable offence is disclosed. Now, specifically, this is a direction that the action must be taken against erring officer who do not register FIR if the information received by him discloses a cognizable offence. So what it does is it clarifies that not registering an FIR is a ground for proceeding against erring officers. Erring officer means officer those are not performing their duties. So not registering an FIR can be a ground for departmental inquiries too. And the next guideline, what it does is it narrows down the scope of preliminary inquiry. So it says next guideline says that the scope of preliminary inquiry is not to verify the veracity or the otherwise of the information received, but only to ascertain whether the information reveals any cognizable offence or not. So it gets more clarified when I read the next guideline. It explains it further. So next guideline says, as to what type and in which cases preliminary inquiry is to be conducted will depend on facts and circumstances of each case. The category of cases in which preliminary inquiry may be made are as under. So it says that it depends on facts and circumstances of the case, but it still in a way directs that it is to be made in these 5 categories of cases. The first category being matrimonial dispute, family dispute. Second being commercial offences. Third one being medical negligence cases. And next one is corruption cases. And last one are those categories of cases where there is abnormal delay or laches. Laches means also delay in initiation of criminal prosecution. For example, over 3 months delay in reporting the matter without satisfactory explanation. And it finally says that these 5 categories are not the only categories. There can be more, and it depends on facts and circumstance of each case. So next guidelines, we have 2 more to go. The 7th guideline says that while ensuring and protecting rights of the accused and the complainant, a preliminary inquiry should be made time bound. So there should be a time limit on completion of preliminary inquiry. In any case, it should not exceed 7 days. The fact of such delay and cause of it may be reflected in general diary entry. So if there is a delay beyond 7 days, so reason for delay must be recorded. For example, you can say today it's coronavirus lockdown and there is another duty, so we cannot proceed, but that should be recorded in the diary itself. So the final guideline, the 8th guideline, says as follows: since the general diary, station diary, or the daily diary is the record of all information received in a police station, we direct that all information relating to cognizable offence, whether resulting in registration of FIR or leading to an inquiry, must be mandatorily and meticulously reflected in the said diary, and the decision to conduct preliminary inquiry must also be reflected as mentioned above. So this basically says that there should be complete recording of each and every step. There shouldn't be anything left to the discretion of the police officer concerned. So that marks the completion of Lalita Kumari directions, and almost every state and every district police office have already issued directions to each and every station regarding the guidelines as are now applicable in each and every state. So you can safely presume that each and every officer concerned who is there for duty of recording your FIR is well aware and knows fairly well about these guidelines. So with that in mind, you can understand that yes, you have right and the police officer have responsibility, accountability, and there is a proper mechanism. It's not his sweet will to whether register or not, and these are your safeguards. So beyond that, I will move on to what to do in cases where police officer or the superintendent of police, as the case may be, refuse to record your FIR, where to approach. As I mentioned earlier, in that case you have approach court of magistrate by filing an application under section 156 subclause 3. Now the powers of magistrate under section 156 subclause 3 is administrative in nature. It means it's not a judicial function, rather it's supervisory in nature. And the nature of power of magistrate under this section 156 subclause 3 is well defined in this Supreme Court judgment, which you can see on your screen. This is Sakiri Vasu versus State of UP and others, 2008, which clearly states that magistrate is empowered both for directing registration of FIR as well as for ensuring fair investigation. So what you can do is you can engage a district court criminal lawyer and you can file application under section 156 subclause 3. Now what you have to keep in mind is that the application you file under section 156 subclause 3, you have to be very specific, and the offense that you want to make out should be made out from the facts that you are narrating. There should not be any improbable version. There should not be element of fiction there that makes the story unbelievable, and you have to properly annex the letter that you wrote to SHO or the superintendent of police along with the postal receipt, so that court is sure that you have taken all the steps as you could have to get your FIR registered. And now if the magistrate is satisfied that yes, the facts that you are narrating does reveal commission of cognizable offence, and you have taken all the steps necessary, for example, you have approached the SHO, you have approached the superintendent of police, and the court is satisfied that yes, you have taken all the steps possible. And one thing more that you have to demonstrate to the court, that your case is a case which needs proper investigation by the police officer. You have to convince the court that this is not a case to be treated as a complaint case, rather it needs proper investigation, that the investigative machinery of the state needs to make proper investigation. So once you satisfy these requirements, your FIR registration will be directed. Now the obvious question that is asked all the time is that can the accused person, the person who I want to mention in FIR, has locus to challenge my application? Do I need to make him a party to the application filed under section 156(3) Crpc or not? So the answer is you don't need to make him party, him or her, whatever. So because the application under section 156.3 is filed at pre-cognizant state, and the magistrate is exercising administrative functions as provided under chapter 12. So it is not a judicial trial for that matter, and hence the rigorous standard of judicial trial and right to be heard does not arise in case of application under 156.3. So with that, the next question, obvious question, is that my application is allowed. I filed an application under 156 clause 3, and direction was given to police to raise FIR. So can the accused person, the person mentioned in the FIR, file a criminal revision challenging the order passed under 156.3? And the answer to the question is no. The accused person cannot file criminal revision challenging the order issued to police to raise the FIR, but unfortunately, as of today as well, criminal revisions are being filed as a matter of practice. The moment direction is given to police officer to register an FIR, the accused person so named runs to sessions judge and files criminal revision challenging the order passed by magistrate. And even though the question that whether such revision is maintainable or not is already well settled in the full bench decision of Allahabad High Court in Father Thomas versus State of UP in another 2011 citation you can find on screen, wherein it was clearly held that an order made under section 156 subclause 3 Crpc is an interlocutory order, and remedy of revision against such order is barred under section 397 subclause 2 of Crpc. Now this full bench decision was again followed and explained by another full bench decision of Allahabad High Court in Jagannath Verma versus and others versus State of UP and other. This is 2014 judgment, wherein the position so held that the order passed under section 156 is an interlocutory order, and hence no revision is maintainable. It was reaffirmed, and this legal position stands today, as of today as well. So no revision can be filed challenging the order passed under 156.3 by the accused. Now there is a small catch here. Second possibility is left out. So the second possibility is that you file an application under section 156 subclause 3 for registration of FIR. By some reason, magistrate court is not convinced, and it proceeds to reject your application. So in that case, where your application is rejected, can you file criminal revision or not? Now this question, whether you can file criminal revision where your application is rejected or not, is answered in full bench decision of Allahabad High Court in Jagannath Verma and others versus State of UP and another AIR 2014 Allahabad 214. The answer was given that in case your application is rejected, yes, you can file. But there is a small catch here. The moment you file criminal revision challenging the order of magistrate where there is a rejection, when you file criminal revision, the accused or the proposed accused will have right to take part in criminal revision and represent his case. Now, the reason that was provided for allowing criminal revision in case where there is a rejection of application under section 156 subclause 3 was that such rejection order is not interlocutory in nature. Hence, it is not hit by section 397 subclause 2, and hence a criminal revision can lie under 397. Now the final question is obviously, what if the criminal revision is dismissed as well? Where should the appellant approach? In that case, the appellant has to move to High Court, and also in the cases where criminal revision filed by the accused is unlawfully allowed, in that case too you have to move to High Court to get it quashed. Now, with this discussion, what we have discussed so far, we have seen all the provisions, we have seen the key case laws, we have seen about the maintainability of applications and revisions before various forums, and we have seen the complete overview of the process right from the beginning to the end. Now, I hope with this information you will have increased confidence whenever you deal with police. Nobody is above law, including the police officers, and if possible, please share this video so that others can be empowered too. One final thing that I forgot to mention is about e-policing services. For example, in state of UP itself, from last few years, a website and as well as an app called UpCop. Up means from Uttar Pradesh, UNP, and COP. UpCop, you can find it on Play Store. These apps and website now provide many facilities, like you can register FIR, you can apply for employee verification, you can apply for character certificate verification, and for permission for dharna and protest, for many other things, and many that conventionally you needed to visit police station. Now you can do all such things sitting at your home through mobile app. So this marks the end of this video. I hope you liked it. If you do, please do share, and see you until next time.